Thank you, Mr. Chairman, and thanks for calling this hearing in the immediate wake of revelations that the DOJ sought the telephone and email records, not just of journalists, but also of two of our colleagues, Mr. Swalwell and Mr. Schiff, as well as even family and staff members, apparently. I want to thank the witnesses for helping us examine the threat specifically posed to the freedom of the press by these practices. I think it's a matter of fundamental importance to American democracy, and I'm pleased to note that tomorrow I will be introducing the PRESS Act, the Protect Reporters from Exploitative State Spying Act, which I've been working on with Senator Wyden for some time, along with my colleague, Mr. Liu. This bill is an update of the Free Flow of Information Act that I proudly introduced in the last Congress with our colleague, the ranking member, Mr. Jordan, in the 115th. It will prevent federal law enforcement from being able to obtain information from covered journalists through their work devices and accounts, as well as their personal devices and accounts, and will also prevent the government from conducting an end run around these prohibitions by preventing them from seeking third-party communications held by computing and communication services, except in narrow exceptional circumstances. I hope that colleagues on both sides of the aisle, as demonstrated by what appears to be broad consensus today, will join us in co-sponsoring this bill and work to defend the freedom of the press against these practices. Ms. Burton and Ms. Oberlander, I'd appreciate it if you could expound on the need to address the secrecy orders being used by law enforcement to prevent targets from even being aware that their information is being sought, and what type of oversight the court should be conducting to rein in the abuse of secrecy orders.
Thank you, Congressman. I would suggest that by having, again, a narrow procedural bill which says that there cannot be a secrecy order without a compelling interest that's been identified, been presented to a judge very specifically, and a judge has actually made a ruling. And that if we did that, you would see very few secrecy orders, because before we had this back door that everyone was going through, it wasn't a problem at the same levels that it is now. So I would just suggest that if we have proper and clear requirements that there is a bilateral presentation to a court, either through the judiciary, which would create some opportunity to hear the other side of an argument if something really was a national security issue, a very narrow set of cases, that would probably resolve the secrecy issue.
And then the secrecy order would go back to being an exceptional
exactly.
case rather than the rule now, because it seems to be pretty perfunctory that they get them now, right?
That's right. It's having a dual process, and it's having a presumption in favor of openness that judges respond very well to in light of all the constitutional rules and cases that have upheld those basic cadence.
Okay. Did any of the other witnesses want to comment on that?
I would only add that there are a couple other things we can do too. So you can narrow the, as we've discussed, narrow the length of time that these secrecy orders are in effect by putting a cap on them in the statute. Right now, in 2705B, there's no time limit, so you add 45 days or 90 days, and that's it. You then have to tell the subject, the media entity, that their materials have been requested. That would help as well. And then the other thing that has been presented in some of our testimony is that in cases where it's truly necessary to not inform the affected media, maybe we can have an independent third party, some sort of advocate, perhaps who doesn't necessarily let the media know that they've been hired, but who comes in and talks to the judge and says, these are the First Amendment, these are the very, very important First Amendment interests here, and you should please be considering them. So adding sort of another advocate to the process.
Let me just stick with you for a second. You noted in your testimony some of the policies that are being used by DOJ to limit the use of subpoenas against journalists, but you observed that these are merely internal policies that are subject to override at whim by future administrations, and they don't address the end runs that are being conducted routinely by law enforcement to obtain third-party data from companies like Microsoft, as noted by Mr. Burt. I wonder, what do you think about the need for a press shield law, given everything that we've learned in the last few months? And maybe I can close just with that question to all of the witnesses.
I am delighted to hear that you're introducing the Press Act tomorrow. We absolutely need a shield law, which will frankly protect from government overreach, but also in private cases as well, and civil cases. And so I really think that is we absolutely need it. And I'm really thrilled to see that Congress is working towards it.
Just if I could go down the line there, Professor Turley, do you agree we need one?
Oh, I do agree. The only quibble I had in my testimony is on it's more than a quibble, but is a disagreement about the definition of covered persons. I also think that it can be tweaked to increase some issues. For example, there's a single line on national security may be considered by a court. That's in the previous legislation. And it really doesn't say how that should be weighed by the court. I expect a lot of judges would look askance at that as a standard.
Okay. And Ms. Burton, do you agree?
I agree, but I wouldn't let that process, which will be a longer process, stop this committee from issuing a bill and a law right away. I think that we cannot underestimate the harm of privacy and the harm of a lack of process here, which to me is incredibly dangerous to the American public. But I do support a shield bill. I think it's a more complex discussion, which we should be reflecting on also.
Thank you. I yield back to you, Mr. Chairman. Thank you for your indulgence.
Gentleman yields back.